Hello everyone. In this presentation, certain facts which are expressly declared relevant under Chapter 2 of the Evidence Act and of which evidence is permitted will be explained. The two fundamental rules on which the law of evidence is based are: no facts other than those having rational probative value should be admitted in evidence, and all facts having rational probative value are admissible in evidence unless excluded by a positive rule of utmost importance. This is contained in Section 5 of the Evidence Act, according to which evidence may be given in any suit or proceedings of the existence or non-existence of every fact in issue and such other facts as are declared relevant under the Act and of no other. Section 5 is designed to prohibit irrelevant facts which have no effect or impact on the facts in issue from being proved, which results in loss of precious time of the court. Thus, this section serves a useful purpose by restricting all sorts of irrelevant, unwarranted, and unconnected evidence from being given in judicial proceedings. Chapter 2 of the Evidence Act expressly declares as relevant certain facts of which evidence is permitted. These facts can be classified under 7 groups. Facts connected with facts in issue contained in sections 6 to 16. Admissions and confessions dealt with under sections 17 to 31. Statements made by persons who cannot be called as witnesses dealt with under sections 32 to 33. Statements made under special circumstances dealt with under sections 34 to 39. Judgments of the courts dealt with under sections 40 to 44. Opinions of witnesses dealt with under sections 45 to 51. And character of parties in civil proceedings and of the accused in criminal proceedings dealt with under sections 52 to 55. The first group deals with the relevancy of facts connected with facts in issue running from sections 6 to 16. The first among this group is section 6, which deals with the relevancy of facts forming part of the same transaction. The principle behind the section is that when a court is dealing with a transaction, naturally all the facts that constitute the transaction have to be gone into. This principle is based on the English doctrine of res gestae, which means things done, and the use of the word is avoided in section 6 because the concept lacks specificity in English law as it is used to express hearsay evidence, circumstantial evidence, and so on. Now, what is a transaction? Transaction is a group of facts so connected with each other as to be referred to by a single legal name as a crime, a wrong, or any other subject of inquiry which may be in issue. In order to make statements admissible under section 6 as forming part of the same transaction, the statement has to be explaining, elucidating, or characterizing the incident in some manner. The statement should be spontaneous or contemporaneous, but it should not be just a narration of what has happened. The statement must be a statement of fact and not an opinion. The statement must have been made either by a participant in the transaction or by a person who has himself seen the transaction. The statement made by the bystander would also be relevant if it is shown that he was present at the time of the happening of the event and he witnessed the event. Section 6 constitutes an exception to the rule that hearsay evidence is no evidence. Hearsay evidence is a statement deposed by a person who has not himself witnessed the happening of an event but has only heard of it from others. Now, suppose A is accused of murder of B by beating him. Whatever is said by A or B or by the bystanders at the beating or so shortly before or after it as to form part of the transaction is a relevant fact. Now, suppose a person is in his room and he hears his servant crying out that A is killing B. When the person rushes out, B is unconscious and A has run away from the scene. But his servant and others tell him what happened. He would inform the police, who would investigate and finally bring A to trial for murder of B. If at the trial the servant and others were not available as witnesses, but the person who heard the cry is called as a witness, his evidence of what he heard would be relevant under this section, though strictly it is only hearsay. This is because the cry of the servant was contemporaneous and spontaneous with the event. That is, it had simultaneously occurred with the event. That is, A beating B, and thus forms part of the transaction. However, if no cry is heard by the witness, but he is told next morning by his servant as to what happened, the witness will not be allowed to give evidence in a court as to what his servant told him, because it is hearsay and the statement of the servant would not come under the section. It is not spontaneous one because there was plenty of time and opportunity for him to think it out. Suppose A is accused of theft. He is seen giving the stolen property to B, who is seen giving it to C, A's wife. B says as he delivers it, A says, "You are to hide this." The question is whether evidence of this statement can be given. Here also the statement is logically relevant to prove A's guilt, but the statement comes under res inter alios acta, which means a transaction between two parties should not operate to the disadvantage of a third, because it was made behind A's back and is to be used as evidence against him. But the transaction is theft and consists of A passing on the property to C. It consists of A stealing the property, passing it on to B, who passes it on to C. Each of these deliveries forms part of the transaction. A statement made along with each delivery is also a part of this transaction, and therefore the statement is relevant and evidence of it can be given under the section. Section 6 applies both to civil as well as criminal proceedings. Section 7 deals with relevancy of facts that are occasion, cause or effect of the facts in issue, or relevant facts, whether they are immediate or otherwise, and facts which constitute state of things under which they happen, and facts which provide an opportunity for their occurrence or transaction. The word occasion here means cause as well as opportunity according to the context. Facts which constitute immediate cause and effect of the fact in issue constitute also a part of the same transaction as the fact in issue. Remote causes and effects do not form part of the same transaction. The concept of cause and effect will bring within purview of this section a lot of facts that can be related to each other on the basis of logic and induction. If a human body is found on the railway track cut into two pieces, logic would suggest the inference that the person died because he was run over by the train. That is, the death is caused by the train run over. If on closer scrutiny it is found that there is no hemorrhage, it can be inferred that the person was killed somewhere else and the dead body was thrown on the track to mislead the police, because if a person is run over by the train, there would have been blood all around. Regarding facts which constitute the state of things, they are the circumstances in which a fact in issue happened, and all such circumstances form part of the same transaction as the fact in issue. Facts which constitute opportunity are also circumstances under which a fact in issue happened. The section also makes relevant facts which are the occasion, cause or effect of the relevant fact, the state of things in which a relevant fact happened, or which provided an opportunity for the happening of the relevant fact. In criminal cases where the prosecution case depends either partly or wholly on circumstantial evidence, courts insist on proof of the fact that the accused had not only the opportunity but had exclusive opportunity to commit a crime, and therefore opportunity for the commission of a crime is crucial. But It is highly dangerous to rely on the evidence of opportunity alone in the absence of substantial evidence to convict a person. Now, Section 8 deals with relevancy of motive, preparation, previous and subsequent conduct. It widens the ambit of relevancy by including motive, preparation and conduct within its reach. Now, what is motive? Motive is something which moves or impels a person to do something that manifests as an external act. Intention is an act of the will, directing an act or deliberate omission. Motive is the reason which prompts the intention. If a person commits theft of a loaf of bread from a bakery to feed his starving children, his immediate intention or intention proper is to commit theft, but his motive or ulterior intention is to feed his children. In this example, the ulterior intention is innocent, but the immediate intention is criminal. But in Section 8, the word motive is used in a generic sense and includes ulterior as well as immediate intention. Motive is a psychological fact, and the accused's motive will have to be proved by circumstantial evidence. There are 4 stages in the commission of a crime. They are intention or motive, preparation, attempt, and actual commission of the crime. Preparation consists in devising or arranging the means or measures necessary for the commission of the offense. Now, where the offense is attempted or actually committed, evidence of preparation on the part of the accused clearly establishes the requisite guilty mind or mens rea. Though preparation by itself is not punishable and is not relevant if the offense is not committed or is not even attempted, preparation is a proof of premeditation where the offense or its attempt is committed. Thus, preparation is the proof of motive, and preparation and earlier attempts provide crucial circumstantial evidence of the commission of the offense. Now, Section 8 also makes conduct relevant. Whose conduct? The conduct of any party to any civil suit or any agent of such party, the state as the prosecutor in a criminal proceedings, the accused in a criminal proceedings, and any person, an offense against whom is the subject of any proceedings, namely the victim of the crime, is relevant under this section. What conduct is relevant under Section 8? The conduct relevant under Section 8 must be with reference to such civil suit or criminal proceedings, or any fact in issue therein or fact relevant thereto, and such conduct should influence or is influenced by any fact in issue or relevant fact. The fact that there was a violent fight between the accused and the deceased a day before the murder and that led the accused to kill the deceased is relevant as the conduct that influenced the fact in issue. The fact that the accused assumed a false name and absconded is also similarly relevant. The conduct of the parties is relevant under Section 8 if the conduct influences or is influenced by any fact in issue or relevant fact, and whether it was previous or subsequent. It is obvious that conduct to be relevant under Section 8 must fall within a certain time frame of proximity, as the conduct must either influence or be influenced by any fact in issue or relevant fact. Preparation for crime and previous threats and attempts obviously come under the previous conduct of the accused. The conduct of the parties subsequent to the occurrence is relevant if it is influenced by the fact in issue. The filing of an FIR by the accused to divert attention of the police from himself is relevant under Section 8. The conduct to be relevant must be closely connected with the suit proceedings, a fact in issue or a relevant fact. That is, if the court believes such conduct to exist, it must assist the court in coming to a conclusion on the matter in controversy. It must influence the decision that would be taken by the court. If these conditions are satisfied, it is immaterial whether the conduct was previous to or subsequent to the happening of the facts in issue. The first explanation to Section 8 says that mere statement is not relevant. This is in accordance with the rule of exclusion that statements made behind the back of a person should not be used against the person. But if the statement accompanies and explains acts other than statements, such statements would be relevant. Statements which accompany and explain acts other than statements can be a complaint or an accused pointing out to the police during investigation various places connected with the crime. The difference between a statement and a complaint is that a statement gives information, whereas a complaint gives information, expresses grief and dissatisfaction, and the complainant hopes that action would be taken against the person against whom the complaint was made. Such a complaint would be conduct, and under the section read with the explanation, the complaint of the victim of a crime would be relevant. Victim is a person, an offense against whom is the subject matter of the proceedings. If the person affected is available as a witness, it makes no difference whether the statement is a mere statement or a complaint, because it is oral evidence given by the witness in court that would be the substantive evidence in the case on which the court acts, and the statement or complaint would be used merely to corroborate such substantive oral evidence. But where the person affected is not available as a witness, then if his statement amounts to a complaint, it would be relevant by itself. If it is a mere statement, it would not be relevant unless it comes under section 32(1), which would be discussed later. The reason why a complaint is made relevant is that a person is not likely to complain unless there is some basis of truth. According to the second explanation attached to section 8, if a statement is made to a person and it produces a conduct which is relevant, then the statement itself would be relevant. Supposing information is given to the father of the deceased by the neighbors about what they heard, it is only a hearsay evidence. But the father's conduct in rushing to the police is relevant conduct, and the information given to him will also be relevant as a statement influencing his conduct. Now, where the question is whether A committed a crime, the fact that A absconded after receiving a letter warning him that inquiry was being made for criminal and the contents of the letter are relevant. Now, this is about the first three sections so far as relevancy of facts are concerned. That is, section 6, dealing with relevancy of facts forming part of the same transaction. Section 7, dealing with facts which are occasion, cause or effect of facts and issue. And section 8, dealing with relevance of motive, preparation and previous and subsequent conduct. Thank you.